Pierce. My profile is in your booklets, and this presentation isn't about me, so I'll stop talking about me there. This is about regulating our principles. As with every mediation session, it's important to put a few ground rules down at the beginning. You're welcome to heckle me, but if you do, I see you as a fair target. Otherwise, please leave your questions to the end of all 4 sessions. Also, I rehearsed this morning, and I found myself disagreeing with myself about 6 times. So if you find yourself disagreeing with me, you're probably agreeing with me. What this is all about is, or this is an outline of how I'm going to go about trying to stimulate the conversation about us at the infancy of our industry in Ireland from a regulation perspective, to influence us in just starting to think about the principles and how regulation can impact upon them, how they impact upon them now, and how they're going to in the future. So the first thing we look at is how do we regulate ourselves now in the absence of there being any laws per se. And then the regulatory considerations around these 4 core principles of mediation. The sources I'll be using are journal articles, and I decided to give a thumbs up to the minute for the use of the hall, and I have there some journal articles from their journal through the Edward Kennedy Centre. I consulted a few of them, bringing it out of just looking at laws, some academic discourse about some of the principles as well. Then also the codes of ethics, focusing primarily on the MII and the CEDAR's codes of ethics and case law from Ireland and other jurisdictions, because there are very few Irish cases, and then the mediation bill in 2012 as well. So yeah, our first problem is we don't have any statutes. There's no rules. So what do we do? In the absence of, well, there are rules if you're doing cross-border mediation. That's very well regulated. But for domestic mediation, there's an issue with there being no regulation. Now, hopefully, mediation bill, in whatever form it arrives, will address a lot of that. When is that coming? Francis Fitzgerald has told me they're talking about it and thinking about it, but nothing just yet. However, that doesn't mean that mediation doesn't have a recognised place in the legislative or regulatory scheme of the country. Judge Charlton, the High Court judge, made this pronouncement: an unnavigable barrier has been placed in the way of any controversy that the mediation settlement agreement embraced. That barrier is the terms of the settlement document. That, to me, is a great endorsement of mediation. He mentioned mediation 85 times in that judgment. It's well worth the reading. So, in the absence of a law, anyway, how do we regulate ourselves? How do we deal with the legal rules in our relationship with the greater world, and particularly our relationship with mediating parties in front of us? So there's no law, so how we deal with it is the law of contract. The law of contract. And the law of contract allows us to regulate our own relationships with parties. That contract is the agreement to mediate. The agreement to mediate has terms in it. If you breach one of those terms, then there can be a cause of action against you. Those terms are the principles. A lot of them are anyway. The other way that we regulate ourselves is we've decided to set up associations. There's CEDARS, there's MII, various others. And being a part of that association allows you to insure yourself. And it's insurance that allows us all to sleep at night, knowing that the roof over our heads won't be taken away the next day. However, I contacted my own insurers, RSA, during the week just to see what exactly is my relationship with them and the Code of Ethics. Because I'm a member of the MII, I got insurance from them. It's nice and cheap because mediators don't get sued in this country, not yet. Their answer to me was, as long as you comply with the Code of Ethics, we're insuring you. So if I stop complying with my Code of Ethics, they'll say they're not insuring me, and the roof over my head's in trouble again. So read the Code of Ethics. It's a big message out of that. Now let's get on to the 4 core principles of mediation. Put away the thumb there, there's only 4 of them. Starting with confidentiality. So, quick exercise of raising our hands. Just before you answer this question, raise your hand if you have received mediation training at any point in your life, or if you are a mediator. Or you just check and see if your hands work. They do? Good. Okay, now an answer to this one. If the answer is yes, if your belief is that it's yes, then I'd like you to raise your left hand, which is the one closest to that door. I'm a bit different from everybody else because I'm facing the other way, so my right hand would go up. Okay, so if it's yes, that you would explain the principles of confidentiality to parties at the outset of mediation session. If it is no, up your right hand. Okay? Well done. You passed your first test on your code of ethics. If you're an MII mediator, you should have put up your right hand there because it's part of your code of ethics that you do that.
Left.
Okay.
Left. Your right.
My right hand. You should put up my right hand. Interestingly, Cedar, thank you. Cedar deal with it a little differently. In their code of ethics, they just say that you're bound to confidentiality that's agreed in the agreement to mediate. So they push it all into contract law rather than being bound into the code of ethics. I find that quite interesting. It's a subtle difference in an approach by one association over another. I think the Cedar one makes more sense because in building your agreement to mediate, you discuss the bounds of confidentiality. Versus as an MII mediator, you're working on a lot of assumptions that you know what confidentiality is all about. Assumptions I'm going to tackle now. This is the future of it. This is what the bill says. This is where it's going. That's pretty much what exists at the moment. Mediation communication shall be confidential and shall not be admissible as evidence in court or other proceedings. However, there are exceptions to that. And that's where my focus is, particularly on exception number 3 here, where disclosure is required by law. Isn't it just a lovely get-out clause? You can just say that and sure, aren't we grand? The problem is, what's the scope of that? What is the scope of required by law? As a solicitor, I'd be thinking, required by law just means what does a judge think? But we don't engage in that conversation with our mediating parties at the beginning of the relationship. So I'd like to see in countries where this has become an issue. So this is an English case, UK High Court, 2011. There's a lot of examples of this. I'm only taking one. This is one where one of the parties claimed after the mediation that they were under economic duress, that they made their decisions in the mediation under pressure, and that because of that pressure, contract wasn't a real contract. Contracts are only between people who have the capacity to make a real decision. And they were saying that because they were under duress, they weren't able to make a real decision. UK High Court said confidentiality could be waived in that scenario, and it can be waived in exceptional scenarios. Trying to find definitions around that is where our trouble is going to be. They also said mediator compellability was allowable. That means making a mediator, summoning them to court and making them give evidence on what happened in the mediation. Mediator argued back, but my agreement to mediate said that I couldn't be compelled on the dispute. Those words, the dispute. So it was in there. The courts came back and said, yeah, that was that dispute. Now we're disputing. This fresh dispute is about that dispute. So it's a different dispute. And the mediator was compellable. Privilege is a subset of confidentiality. Don't want to go on. That's another day's work of only 15 minutes. But it said that that's owned by the parties. So the mediator pleading their own privilege. Okay. Next question. I fully understand the legal concepts of misrepresentation, duress, and mistake. Yes. My right hand, your left hand. No. My left hand, your right hand. Okay. So just go back one. There was a misrepresentation going on there. You already said that you explained confidentiality at the outset. In Pharmacist, they didn't explain that. See where I'm going with it. We move on. Tony Allen's take on all of that, and I got this line of argument from his book, Mediation, Civil Law and Practice. It's very worrying for mediators not to know the precise boundaries of the confidentiality which lies at the heart of the success of the process that they deliver. It's a very good chapter in his book. Here it is, Exhibit A. So what you can do to protect yourself is the wording of the agreement to mediate. So obviously all the agreements to mediate in the UK now have this dispute and all related disputes. And they get around the problem that arose in Pharmacist. Also you can put in a parting waiver. At the end, when there has been what people believe to be a legally binding agreement reached, put in a waiver, which is them signing to you to say they understood what they were doing. What I tend to build into agreements that I reach with Succession Ireland is a 14-day cooling off clause, where they say that, where parties say they will go and consult with their solicitor because we're dealing with succession issues and rights over land. Then also, if there's something that one of the parties is relying upon, and that forms the basis of the agreement they will end up in, that should be itemised at the start of any contract. then they can't turn around and say that the other party can't hide behind the mediation and say this can't be produced. If you're trying to rely on a fact, put the fact into the agreement, and then if it is a lie, it will come out when the agreement itself is challenged, without needing to go into the content of the discussions.
Can you give an example of your time?
Afterwards. Jerry went to heckling school, it's very good. Impartiality then. We'll move on to the next concept. Okay, what's this a definition of? Hands up if you think that this is a definition of arbitration. If you think this is a definition of conciliation. If you think this is a definition of mediation. This is the cattle mark version of putting your hand up. It's a definition of conciliation which I took from the Law Reform Commission's report. The reason why is because of those two words in the middle. Actively assists. We're talking about impartiality here and neutrality. When you actively assist, you stop with that basis. At least that's what the Law Reform Commission say. This is the definition of mediation, the current running definition in the mediation bill. This is how it differs from conciliation. In my mind, this is me messing with words now, and I've highlighted two of them to say this is how it's different from conciliation. Mediation, we say they do it by themselves, whereas a conciliator, you're allowed to get down and dirty with them. Then this is versus arbitration. In arbitration, it's not voluntary anymore because the arbitrator can make a decision. Just a nice way of playing with the words. My email is in the last slide. If you want the slides or any of the references, just send me an email. How the mediation bill is going to deal with it is that they would say mediation is facilitative only, but thankfully they bring in the Clark Kent Superman clause, which is, with the agreement of all parties, you can turn into a conciliator. You may turn a value out of it. So it's like your Clark Kent, and then the telephone box is everybody's agreement, and then your Superman. You go from being a neutral mediator to an evaluative facilitator. Interesting, just from Michael Lang told us to read the journals. I did his bidding earlier on in the year, and this is one very interesting that I took in relation to impartiality. In workplace mediation, optics and doubt, where the employer is paying the mediator and the mediator wants to sustain their business, there is naturally a doubt in relation to their neutrality. How impartial can somebody be? It asks a lot of good questions around that area. He also looks at the dichotomy and the inherent contradiction between impartiality and empowering another party. Facilitative mediators are safer mediators. The less you evaluate, the less likely you actually suit, in my opinion. That's an Australian case. In that one, evidence from within the mediation was brought into court, and the mediator was found to have steered it too much. So they could have been liable then for a negative outcome for one of the parties. While it didn't go to full trial, it got settled. Indemnity premiums for mediators in Australia went up very, very quickly and quite steeply. Voluntariness then, this is what the mediation bill is going to say. You can withdraw whenever you want. Question, should courts mandate mediation? Yes? No? It's definitely the safer way to feel. I will argue yes, just for the sake of being different. I say that voluntariness is within the mediation. You can be compelled to go there, but you can leave whenever you want. And I think it's powerful when you meet a human being who says, you can go whenever you want, just give me a moment to explain what this is all about. I like the way that North Carolina, on the right here, deal with it. They have a system of opt-out. So it's automatic that you should be going, but you can opt out. It just changes the focus of people's mindsets. Yes, and this is a part of the process, on we go. How it's actually going to be dealt with in Ireland, Legal Aid Board will start with themselves. This is what the bill says. We'll invite parties to mediation or direct them to an information session. I think with the resources in this country, information sessions will just be turned into DVDs and people won't get the human connection and they won't go ahead with it. Finally, self-determination. I should self-determine and just finish this right now, but I'll give one more minute. Just two interesting articles on this issue. Self-determination is illusory in a recession like this, where it's the banks who determine the decisions anyway. Interesting article by Magella Foley-Friel. And then self-determination. By us hanging on to self-determination and voluntariness so hard, those two principles, Aisling Parks argues that we are violating the European Convention on the Rights of the Child. You've heard more about that earlier on in the conference, so we'll leave it there. Thank you very much.